All right, everyone, good afternoon. Thank you for coming. We'll go ahead and get started with our panel on the subject of who's in charge from different perspectives in the hearing room. I am Andy Frischknecht. I am a partner with Chaffetz Lindsey here in New York, and we are very lucky this afternoon to have two esteemed panelists with us in person and one joining by video link, which I will briefly now introduce. To my right is Emma Vidak Gojković, who is an independent counsel and arbitrator, specializing in international arbitration and public international law. Before founding her independent practice, Emma practiced in leading international law firms, including King & Spalding in London and New York, Baker McKenzie in Vienna, and Omnia Strategy under Cherie Blair QC in London. Emma has a mixed civil and common law background. She holds degrees from Harvard Law School and the Zagreb Faculty of Law, and she is triple qualified in New York, England and Wales, and Croatia. Throughout her career, Emma has represented clients in commercial and investment arbitrations under all of the major arbitral rules, and she sits as well as an arbitrator in both ad hoc and institutional arbitrations. She's also appointed to the ICSID panel of arbitrators. To my left is Santens from White & Case. She's a partner in White & Case's international arbitration practice and heads the firm's America's Disputes section. She serves as both counsel and arbitrator in commercial, investment, and construction arbitrations around the world under all major international arbitration rules, and has a particular focus on energy, including oil, gas, electricity, and renewables, as well as infrastructure. Ank is fluent in both the common and civil law legal systems as well. She has been described as a very well-respected arbitrator and practitioner. Ank is a court member of the London Court of International Arbitration and a member of the board of the International Institute of Conflict Prevention and Resolution, Delos Dispute Resolution, as well as the New York International Arbitration Center. And finally, last but not least, joining us by video link is Olena Perepelynska. Olena is a partner and head of arbitration at Integrites law firm in Kiev, Ukraine. She has acted as counsel in about 90 international arbitrations under various rules. She has also served as arbitrator in more than 70 arbitrations seated in Almaty, Bishkek, Kiev, London, Minsk, Paris, Vienna, and Stockholm. Olena serves as president of the Ukrainian Arbitration Association and a member of the ICC International Court of Arbitration, as well as vice president of the ICC Ukraine. So with thanks to the distinguished panelists, I think we'll go ahead and get right into the middle of our discussion. We thought that it would be interesting sort of to get a show of hands on a couple of basic fundamental questions that we're going to use to kick off our discussion this afternoon. And so I have two questions for the audience, and I just ask for a show of hands. These are sort of either or questions. First one is, do you see international arbitration as more of a public service that is akin to a judge, sort of administration of justice? Is that its essence? Or is it more of a service provider role where it's all about achieving the parties' objectives? So how many of you think it's more of a judge administration of justice role that's key? On the chat, if we're able to get that answer as well, please feel free. Or is it then a service provider role? I take it that's the view of the room. Okay, that's a pretty clear majority of however many to zero. I'm gonna see if my panelists have any different or additional thoughts on that subject.
There was one different vote in the back, which said this, so, which I think is how most of us think about almost any question almost all the time. But on this particular question, we do start from the idea that the goal is to deliver a just decision in accordance with the law, one that will ideally be enforceable, so not just a piece of paper. But equally, we want to satisfy the parties' expectations. For me personally, the letter, thinking about parties' expectations, really matters, really matters. And I don't assume a lot about these expectations. I like to have a dialogue about it. Okay.
I would go with this one, with that answer on this one. I do think the primary role of an arbitrator is to be a service provider and to prioritize the expectations of the parties. I do think there is a justice and judge making function as well. And I think the level of that function depends on the type of arbitration we're in and the history and what arbitration is intended to do. Commercial arbitration, I think, grew very much as an alternative way to solve business-to-business disputes where businesses want a resolution and they want to move on. But arbitration, of course, is also used in a lot of other contexts. For instance, the investment treaty context, where I do think the service of justice function is heightened as compared to a commercial arbitration. It arises, investment treaty arbitration arises out of a different history, out of a different instrument. It doesn't arise out of a contract between the two parties to the dispute. It often entails disputes relating to enactment of laws or regulations that have a public purpose that may be disputed. And it involves potentially the payment of public money. So I think in those types of disputes, there must be from the arbitrators an enhanced attention to the justice function and the judge function. Another example, I think, is sports arbitration, where, again, that's a very specific form of arbitration in a specific area, where I do think, again, the judge function has a higher role and importance than in commercial arbitration. And then I was thinking other areas that I'm not involved in, but like employment and consumer, I think there too, there's a slightly different perspective because there's not necessarily equal representation of the parties, etc. And so there, I think as an arbitrator, you also have to think a little bit more about what your societal function is, let's say, in the resolution of the dispute. But in pure commercial arbitration, I think it's 90% service provider, and the judge function only comes up in difficult areas, actually, areas on the margin, which I think we'll discuss a little bit later when we get into more concrete, specific examples.
Thank you for that, Anke. Can I ask Olena as well to chime in?
Yeah, thank you. I would echo the last presentation, but would add probably that the attitude of an arbitrator towards his or her function would depend on his or her background. And this is not only about civil law or common law background, which would have impact, of course, but also whether this arbitrator has ever acted as a counsel, because this would change the perspective immensely. And I think that those who have had counsel experience would tend to have a larger portion of service provider approach. But we have many arbitrators who have never acted as counsel, who has either academical background or some other which is not related to counsel work. And in my experience, sitting with those arbitrators in the tribunal, so according to my observations, they tend to incline to this administration of justice function rather than to service provider. So they tend to think at least in the categories of justice. And this is also quite interesting. We know that the majority of arbitration laws and rules, they do require an express consent of the parties for the arbitrator to decide the case like exactly bono as amicable compositor, but the reality is that many arbitrators, even without that consent, they do measure or they do approach their decision-making process from their internal justice feeling. I would tend to say that it's probably close to this judge function, and that is why I do agree that there is still a portion, there is still a mix, and there is still a portion of this administration of justice approach. But I also agree that the major part of it should work as service provider approach. Thank you.
So I think there's a pretty broad consensus here that the service provider role is perhaps the dominant, or at least a very important aspect of the process and of being an arbitrator. So if that's the case, I think the question then arises, if giving the parties what they want is the objective, how does one determine what the parties want? And so I think that's the next question. I think I can maybe kick to you first, and to ask for your thoughts.
Sure. I think the key juncture to get the parties' expectations is the initial procedural conference or the case management conference, or whatever you call it, and the lead up to that. That is really where it is and should be discussed what the parties' expectation of the process is. I tend to like written exchanges before there is a meeting, but I do think it is very important to have a meeting. And I think it's important that the meeting not be just, which sometimes happens, set is, okay, we've agreed everything in paper, let's just rubber stamp that and move on. I do think it's important to try to have a dialogue at that meeting. I think it's really the meeting where stakeholders are all together in a room for the same time, for the first time, and it's where you can really get a sense as counsel, when you're counsel for the arbitrators, and vice versa when you're an arbitrator for the counsel. And I think it's also important to have a party representative at the initial conference. I tend to ask for that when I'm an arbitrator, just to make sure that they've heard what was discussed and they're on board with it. And I like it as counsel too, by the way. I like my client to be present. I like my client to see the tribunal. I like my client to feel the dynamics and to see what the process is like. And I think that's very important. That's my initial answer. So that's a very important first juncture. I guess then we'll probably get into it a little bit more, but then over time, I think the tribunal should be clear that it's open for business. And if there are any issues, the parties should feel free to address the tribunal. I think that's an important one. And then of course, there's the pre-hearing conference and the hearing itself. But to me, the initial procedural conference is really a really critical moment in the arbitration.
Olena, any comment on Ank's comment just now?
Yeah, thank you. So I think the starting point would be to look at the arbitration agreement and whether the parties have referred to any institutional rules or any other rules like IBA, Prague rules, etc., any other set of rules which could somehow describe their initial expectation of the parties, not counsel, but the parties with regard to the proceedings. Because when the party chooses a particular set of institutional rules, they also agree, for instance, to expedited procedure, which could be opt-out, or there could be some rules on counsel conduct or some other issues regarding the procedure, which could be quite particular in some instances. So that would be step number one. Then, of course, it's important who are the counsel and the origin or jurisdiction from which the parties are, just to have a general idea, but this does not necessarily indicates whether a particular party would expect certain kind of the proceeding, because again, the counsel could have studied in common law while being from civil law jurisdiction, or have some experience in proceedings with like more common law background. So this does not necessarily mean that when you have a counsel from a civil law jurisdiction, that this counsel would expect the proceedings which is like more close to civil law rather than the common law traditions. And I do agree that yes, the communication is a key, because if you don't ask, you will never know exactly what to expect, and the better way to meet the parties' expectation is to actually to ask them about these expectations. Thank you.
So Emma, maybe just to follow on from what Olena just said about asking the parties directly, perhaps what they want. Is it fair to make certain assumptions about things we think are universal positives? For example, is efficiency something that a tribunal can just assume the parties want, or is that something where you would want to have a discussion about?
I will answer your question, but could I also answer the previous one? I have a view.
Of course.
I agree with Ang's and Olena's points. I want to say though that I think the moment when you start gauging what the parties want starts way before PO1. I think it starts before you're appointed. I wrote an article almost 10 years ago now, titled "Puppies or Kittens." Now a title, which I hope would attract interest, even though it's a legal article, but it has puppies in it. And we, with Michael McEnroe, Lucy Greenwood, and I, who co-authored it, advocated for, is that arbitrators should publish clearly their procedural philosophy on their websites, on institutional websites, in their CVs. Just tell people what you stand for. Tell them how you handle cases, tell them what principles you apply, and encourage parties to have pre-appointment interviews to discuss what they want. Now, I have it on my website. Many other arbitrators have it on their website, and you can tell what I stand for. I stand for civility, dignity, commercial reality check, many things that I hope parties would know when appointing me. On that basis, I courageously assume that when someone appoints me, that's because they want at least some of these characteristics reflected in their cases. So that's the starting point. And then PO1, again, even before that, there's a big debate, like, should you send a template draft PO1 to the parties? I mean, I actually would like to know what people think. Like, do you like to receive a draft PO1 before the PO1 conference? Okay, well, do any of you think that it actually harms innovation, harms discussion? Okay, it's interesting because we had the same question in Montreal Canadian Arbitration Days, and many people thought that it might actually discourage innovative discussions because you see the usual template, usual procedural phases, and you don't propose more in fear of annoying your tribunal. So that's like one question you can think about. But now moving, Andy, to your question, which you actually want to hear me answer. What was it?
It was so good. It was really memorable. It was whether things like efficiency are universally something you should assume parties
That's a
want.
great question. It deserves being memorable. Sorry. I mean, there are ways you can conclude that based on parties' agreement. If they, and this is actually Olena's point, I want to give her the credit for it. When we discussed this panel, she mentioned that some arbitral rules, like the ICC rules, mention efficiency as one of the procedural principles. So if the parties incorporated ICC clause in their arbitration agreement, maybe you can assume that that's what they were looking for. However, I am always skeptical of the drafters' ability to convey the opinions of the parties after the dispute has arisen. So clauses are drafted usually by transactional lawyers. Many of them don't talk to us. They don't fully know how to express what the procedural needs will be. And more importantly, some parties might change their mind once the dispute has arisen. So should you assume anything based on the clause? Maybe a little something, but should you talk about it with the parties to elicit joint positions ideally? Or if nothing, briefs from each party, and then on that basis to decide, I think you should.
And oh, sorry.
Of course.
Go ahead, Olena.
Just wanted to follow in Emma's comment, a short quote from the note, ICC note to the parties and arbitral tribunals. So the arbitral tribunal as a party must conduct, this is point number 92, must conduct the arbitration in an expeditious and cost-effective manner, having regard to the complexity and value of the dispute with reference to Article 22.1. And I also have several reference to LCIA rules, but we'll give just one. Conduct of the proceedings. So the arbitral tribunal's general duty at all times during the arbitration shall include a duty to adopt procedure suitable to the circumstances of the arbitration, avoiding unnecessary delay and expense, so as to provide a fair, efficient, and expeditious means for the final resolution of the parties' dispute. So again, the choice, this is just to underline that the choice of institutional rules might include the choice for some quite expeditious conduct of the proceedings and as an obligation imposed not only on the tribunal, but sometimes on the parties as well. And that is why it could be quite impactful. And with regard to the PO number 1, I would just want to mention from, as a lawyer from civil law background, for me, it was in several occasions quite strange to receive a PO number 1, especially in a dispute between two parties from civil law jurisdictions, or even civil law and common law jurisdiction, but from a presiding arbitrator from common law jurisdiction, already with some stage of disclosure of documents, etc., which party have not even asked for and probably not contemplated for, but the tribunal already not imposes but offers or gives it to the parties to discuss without their initiative to do that. So in that sense, that might be indeed harmful. So it's better to receive some kind at least of ideas of parties' expectation with regard to the rounds of submissions and major stage of arbitration before the tribunal would circulate a kind of draft timetable. Thank you.
Thank you, Olena.
I don't want to disrupt your process, Andy. So, are you going to come back to pre-appointment interviews? Otherwise, I would just.
I think why don't you address that now?
So I was surprised to hear that you encourage pre-appointment interviews. I'm not sure that should be encouraged. I think there's a lot of mischief that can be done in pre-appointment interviews. I do think sometimes they're useful when to ensure a level playing field and to cure asymmetry in information between the parties. But unilateral pre-appointment interviews, I think there was a lot of mischief. I've been asked to have them when I'm under consideration for a party appointed. I keep them very brief. And when I feel questions are targeted at a specific answer, I typically don't answer the question. I really think they're very dangerous. And when I'm interviewed as a party appointed arbitrator, unless they are appropriate at the end of them, I will always make sure I make my role very clear, what I think it is, which is that the party's position should be heard, it should be understood. But in the end, I should be neutral and decide the case in an independent way. And a few times when I've made that speech in the end, I haven't been appointed and I didn't regret it because I wouldn't want to be appointed under any other assumption. I do think joint interviews can be useful of a potential presiding arbitrator. And I haven't done many of those. I've done a couple and I have found them helpful. But again, I'm surprised at the encouragement of pre-appointment interviews. I'm not sure that that's best practice.
No, I think I have to give you a chance to respond to that.
No, happy to answer. So you are right, there is a risk, and there are ways to manage that risk. One way, which many people do, is you record them. The fact that they're recorded usually discourages any mischief. Second is you make it very clear what the topics of discussion are. And for example, on my website, I make that's super clear. It's going to be my availability, my expertise, and your procedural preferences. And I say very clearly, I will not discuss the merits of your case, but I will hear what your expectations are about the process. Now, if after those,
Here, but do you
Yeah.
respond? Like,
well, I
so
mean,
if they ask, are you in favor of document production? Would you respond to
but
that
who
answer?
knows in an abstract? I mean, I would be surprised if anyone has a strong view in an abstract. I mean, I would really love to hear from the parties and then decide. So will I give you a blank answer in an abstract? Wow, no, I think I'm way too experienced for that. I mean, we've all seen like cases left on or right. So, but
I'm
to
just
our end, yeah,
asking, so I'm asking, so if they ask you any type of question, are you in favor?
yeah.
So you
No, there are
do,
questions like, will I tolerate uncivil conduct towards a witness? No, absolutely no.
okay.
So yeah, there are things I can say directly, but you know, what are your views on contra interpretation? Well, right. So, but you're right that those risks should be something we're all aware of. And no one wants to get to the point of an award issuance and then set aside. That's, in my view, a failure of a process if it arises from procedural mischief, which could have been managed, right? So I think that it should be managed, and there are ways to manage it.
Well, as we can see, there's some strong views and interesting different perspectives on some of these issues. I think I don't want to wait till the end to open this up to the audience, at least for some questions about what we've heard so far. Are there any questions from the audience or points that folks would like to raise? Please.
I don't have a question. Well, maybe it's a question, but experience. The worst cases I have are quote international cases. This parties from different jurisdictions, but they're all American lawyers involved. American lawyers just walk in court. American civil litigation. And I, in the preliminary conference, try to lean on them, thinking of efficiency and everything else. But I haven't found a beautiful technique yet when they're both insisting that they want depositions and this, that, and the other to go on forever, which I think is not good for efficiency. Does anybody have effective techniques they've used in that situation?
Maybe Olena, I'll allow you to respond to that one first.
I am not sure that I've heard everything correctly. Andy, could you please summarize the question? I'm not sure.
I'll try to speak a little louder.
Okay.
The worst kind of cases I have are cases that are, quote, international, but we have American lawyers on both sides. And American lawyers want to import all the procedural aspects of American litigation, which is not efficient or normal, but they both want. And
Okay.
so does anyone have an effective technique? I push back on them, but I haven't found the right secret to get them not to keep insisting on all this unnecessary discovery.
Okay, but are you asking this question from the arbitrator's perspective or institutional perspective, arbitrator's perspective? So I have seen this, actually, this is not something unique. I have seen this also having counsel from the UK wishing to have a proceedings which is similar to the UK litigation, English court proceedings, and it might be quite challenging, for if you are an arbitrator from a civil law jurisdiction, and probably this would depend on several issues. Actually, what to do? I don't think there is a one fit-all solution. First, it's important who are the arbitrators. So if you're the only civil law arbitrator and the other two are common law, probably that could be helpful, and you still could have the proceedings the parties expect. Again, we are going back to the parties' expectation here. So why they have appointed such a tribunal, and quite often the party, as Emma mentioned today, so the arbitrator has certain profile. And depending on that profile, the parties could have expectations of some procedural inclinations here of a particular arbitrators. And if the parties appointed for instance, a tribunal composed of civil law lawyers, they probably expected not to have American-style court litigation proceedings in arbitration. So, and that is why probably they expected to have some, I don't know, memorial style and more like concise proceedings. But if they still have, yes, sorry, but if they have a majority composed of common law lawyers, probably the expectations would be still to have the proceeding which is close to litigation in some common law jurisdictions. And the starting point would be if we are talking about this first scenario. So when you have, for instance, sole arbitrator from a civil law jurisdiction or the tribunal composed of lawyers from civil law jurisdiction, probably the starting point would be to look at the rules, then probably to invite the parties, not only the counsel, but the parties to the first case management conference, again, to discuss the parties' expectation, but because the parties might realize that this is cost-consuming exercise, which might be unnecessary, actually. And if they couldn't understand that there are different scenarios, different options, they could actually make right decision and somehow influence the counsel conduct. But this is a dialogue. I cannot give you a kind of solution how to solve this, because this would depend on many different factors.
Let me give my perspective and then. So I think the scenario that you highlight is a scenario where most arbitrators would all be American arbitrators as well. I do want to disagree with you that American lawyers will always invariably want to import US litigation techniques into an international arbitration. I think it depends very much on who the American lawyers are.
And experience.
And yes, exactly. There tend to be litigation lawyers who have the fortune of having a client that has thrown them an international arbitration where they don't have the experience. And I do want to push back a little bit on Olena's notion of a civil law arbitrator versus a common law one. I actually find that I have more in common with somebody who does a lot of international arbitration than with a US litigator, even though I've been based in New York for 22 years. In a situation like the one that you're highlighting, I do agree with some of what Olena said. I think looking at the rules, looking at the guidance, telling them about the IBA rules of evidence, have they read them? If you do an ICDR case, point them to the guidance of the ICDR. The depositions are not supposed to be used in an international arbitration. All of these sources are helpful. I actually remember doing one case where I had New Jersey litigation counsel on the other side. I was counsel. And I sent them Craig, Park, and Paulson on ICC arbitration when we had an ICC case. And the attitude completely changed. And I was amazed. And at the end of the case, he came to me and he said, I want to thank you for sending me that book. And I did it a little bit ironically, or there was a number of motivations, but it actually helped. Now, I was lucky this was a lawyer who was willing to pick up a book and read it and think a little bit and reflect a little bit. I'm not sure all would have done that, and I still like him for it. But I do think education is key. And I do think if you can give the lawyers the understanding that have to understand that they're in a different universe and they need to try to adapt to that, I think you can go a long way. And the other thing I would say is it's of course important that the tribunal be unified. If there are different views on the tribunal, then I'm afraid this is a very difficult situation to get out of. I think if the tribunal is unified, then you can agree to impose some reasonable limits. I think you'll go further than you would with other counsel, but you would want to impose some limits, and I certainly would.
Well, I don't want to beat a dead horse.
Yes.
I've had several occasions where I'm the sole arbitrator.
Yes.
And it's two American lawyers.
Yes.
who are in
That's very
this,
difficult.
And they want to import all this stuff. And you say it's the party's process.
Yeah.
But I have an obligation to be processed. And I was up and down. I have done that. they get very unhappy when they both say, we want this, we've agreed on this discovery schedule, it's ridiculous for an arbitration. This is what we want.
Yeah, and I understand them too. Again, I'm both counsel and arbitrator, and when I'm counsel and I agree on something with the other side and tribunal thinks otherwise, I get pretty pissed off
Yeah.
too, to say it very bluntly. But I think that in that scenario, I tend to be reasonable. I've done this for a long time, and so then when the counsel, I do think when you're sole arbitrator and you are in this situation, you're well within your rights, and I think you're right to put some limits, but they will be, I think, further. Somehow, yes, I think you'll allow more than you would otherwise, but you do need to put some limits, and you can point to efficiency and all these tools to do so, and you would never be overturned.
Just to carry that subject and make it a little bit broader, I mean, the real question, I guess, that comes, this is an example, document production, discovery, US style proceedings, but in general, what is your view on whether ever, or if so, when, it's appropriate for a tribunal to allow something or not allow something that the parties both want? Is that ever appropriate?
So excluding absurd situations where what parties want is so obvious against the rule of law or so obvious against the mandatory principles of either international law or the law where the arbitration is seated, I would almost always have to think very hard whether the parties by their joint agreement or what they're doing legally is modifying the arbitration clause by joint agreement, in which case that becomes the framework for my role. And in fact, on the previous question, I thought there was an assumption built in that I disagreed with, the assumption being that my role is to convince parties who are in agreement that they should do something different. But my role is to make sure their decision is informed, especially if one counsel is a little less experienced or maybe unrepresented. But if two parties are in agreement about something, I may not like it, but it's within the scope of reasonable. I would not want to be in a position where I want to convince them both that they're wrong. That's really not my job. My job is to do, to decide the case within the parameters they're giving me, assuming they're in accordance with the rules. So there was one situation I can think of where I disagree with the party's proposal. And I trusted that I would be able to communicate clearly my questions to the parties. So at PO1, well, what happened was this. Both parties did not like disclosure. They wanted to do away with it to some extent. But what they proposed was very weird. They proposed that they put two deadlines in the procedural timetable. One, for them to exchange a complete list of every document in their possession. And then the second deadline for them to send it over. And that was it, called disclosure. And I looked at that and I thought, wow, well, you are very optimistic. You will probably disagree about what you send to each other. You'll probably want my assistance in some of these things. Plus, possession or under your control are two different things. They're documents you don't have in your possession, but your client might have in their control. So at PO1, I actually talked to parties about it. I said, I see this proposal. Can you tell me what is your thinking behind it? And then I explained, well, we don't want to spend more than X epsilon amount of money on this, and we don't want to have Redfern or Stern or anything. So we together found a solution for what they wanted, which did effectively overturn their initial joint proposal. But it wasn't imposed, it was a conversation that then brought about this outcome. And I think that's probably the best way to go about it, in a dialogue.
I want to raise one particular issue that I think is sort of thorny and complicated and really unpleasant, but does unfortunately happen every now and again. What to do where a party has second thoughts about its own party appointed arbitrator after the fact, and how to handle that. Maybe I'll give that one to you first, Hank.
Yeah, well, I raised it in our panel prep because it arose in a specific circumstance, and I think it'll explain the question a little bit. So we had a situation where the case was started, and with a certain counsel who appointed a certain arbitrator. And then we came into the case very early on, before even the first procedural meeting. And the arbitrator that had been appointed was an arbitrator that we knew had some specific beef with White & Case, which is the firm that I'm at. And so we were very concerned that our client's party appointed arbitrator was an arbitrator that we knew was not favorably disposed towards us. And so we politely asked the arbitrator, the tribunal hadn't been, the presiding arbitrator hadn't been appointed yet. So we politely emailed the respective arbitrator asking him if he could kindly step down, and he refused to do so. And we were very surprised. And so that's why it was just a peculiar situation that we were in. And I was just very surprised, because if that were to happen to me, I would have stepped down immediately. You're very much in the beginning of the case. If this happens later in the case, it's a very different scenario, by the way. If the case is midway, then we knew this was the arbitrator, we just shouldn't have taken the case. But this was very early on. And so I just found it astounding that at that juncture, this person, who my guess was very much in need of a case and so didn't want to give it up, didn't step down. So
may I add here, as I had a similar situation, but on the other side. So the case was initiated by a quite unexperienced counsel who appointed, as I understand, his body, and then that counsel was removed by the party, and an experienced arbitration law firm stepped in. And what they did, seeing this arbitrator appointed on behalf of their client, they disclosed, like in the interest of full and frank disclosure, that this guy has been appointed in at least 3 other cases by the same party. So we used this as of course, as a cost to challenge that arbitrator, and they agreed to that challenge immediately. And that arbitrator was removed, and then they appointed another one. So this was also like, I understand that this is depends on facts. So not always you have such an opportunity, but this is also a solution.
Let me switch gears a little bit now to a slightly different issue that's sort of another fundamental one, which is how active the tribunal should be in its management of the case, specifically as it concerns whether and to what extent arbitrators should raise difficult questions at the outset proactively, or whether they should leave it to the parties to raise issues as and when they arise. Emma, do you have a practice or a preference on that?
Yeah, I have a view. So I think a lot depends on the nature of issue you're encountering. Is it jurisdictional? Is it one pertaining to the merits or quantum? And a lot depends on what constellation you have. Do you have 2 counsel, which is ideal, doesn't always happen. You have one party which is unrepresented, or even worse, one party not participating. So somehow, like on the on the diagram of these issues, I can decide whether it's really important or not to raise an issue. But if an issue will drive my decision, I will raise it. Because I think the worst thing you can do to the parties is to surprise them with your reasoning in the award. They should get a chance to brief you. In my past cases, I have raised on a few occasions jurisdictional issues. It was the easiest to do that when I had non-participating respondents and a layperson represented a respondent. Sometimes parties were welcoming of that intervention and understood that what I'm doing is helping the integrity of the award. On one occasion, the claimant was not thrilled that I raised a jurisdictional issue But I think ultimately was very happy when receiving a positive award, which was also stronger because I addressed the jurisdictional issue. It also depends whether parties, I think, have a civil or common law background and are faithful to the description. What I mean by that is we often use proxies. We expect that people from certain countries think like most lawyers from that country. And that should be tested. Like my original qualification is from Croatia, but I'm a very healthy mix of civil common tendencies. And I'm sure Ank is as well. But sometimes lawyers from civil law jurisdictions would expect more intervention by the tribunal. So it's good to explain to them that it's not your role to plead their case for them. And I sometimes do that, especially if it's a less experienced counsel or a layperson represented counsel. Yeah.
Olena, any thoughts from your perspective on how you approach?
Yeah, I would like to add here that one of the tools probably either to manage the party's expectation or to give some, so first understand whether they want it and then to understand whether you want to be more active as arbitrator or not, is also use of different set of rules. So as an example is Prague rules, actually elaborated for parties from civil law jurisdictions, where the tradition is exactly as Emma just mentioned, to have a more proactive adjudicator, proactive judges, proactive arbitrators, asking questions, trying to figure out, to narrow the issue for themselves. So which might be perceived for unprepared parties as a probably even as a bias, because a certain question could be understood as help in one party or another. And that is why if the in the outset of the case, you agree with the party, the application, at least to a certain extent, of the Prague rules, the parties would actually understand that they will have a proactive arbitral tribunal. I once offered that application of these rules as a guidance in a case where I had a non-participating party, and for me it was important to have this tool actually to asking question from the only party participating in the case in order to establish the facts I needed in order to then render an award. I was a sole arbitrator with the one active party, and Prague rules really gives these tools to an arbitrator in order to get what he or she needs in order to draft the award. So, actually, I would say that the standard and the probably approach of an arbitral tribunal in a case where the of a non-participating party is really different, because you cannot expect that there would be just two parties presenting their case, objecting or non-objecting something. You don't have a position of the other party at all. And in such circumstances, you need to have some minimum information in order to draft the award. And with regard to the surprises, actually in ICC, you do not expect to render a surprise award. So you need to give the parties an opportunity to present their position on every issue. And this is one of the points for scrutiny. And as I understand, in some jurisdictions, a surprise award could give a ground to set aside that award in the future. So this is something to be avoided, definitely. Thank you.
If I could raise a slightly different but related issue, and I'd be curious if you could sort of illuminate this both from your experience as counsel and as arbitrator. Once a party has taken a position on something, on a procedural issue in the case, how easily should it be permitted to change that position without good cause, or to what extent should the tribunal hold that party to the position it's taken?
I think a particular party should be held to the position they've taken. There may be different circumstances, but in the same circumstance, I mean, you mean something has been recorded in procedural order number 1, for instance, then they want to do something else later on. The presumption is they must be kept to the agreement that was struck. I think if the circumstances are different, then that's different. But I do think the rules of the game are decided in the beginning, and there would need to be some pretty good explanation for there to be a change. But you might have a more specific example that I could comment on.
Sort of a recurring example would be, submissions that are not the surreply that isn't really envisaged in procedural order number one. A party says, I have a right to, there's always some reason, there's something new that was raised. It's debatable whether it's new. How liberal should the tribunal be or not with those sorts of issues?
I think a tribunal should try to foresee as much as possible at that initial stage. And I do think there are a lot of tribunals who don't foresee enough at the procedural order number one stage. Now, you can't foresee everything, but I do think you can lay down some general ground rules that help with specific application later on. I do think it's useful to put in procedural order number one that a party is supposed to put its entire case forward in the first memorial, and that the second round of submission should be a reply, really, and not all of a sudden a lot of things that could have come in the first round come in. I do think that's unfair. I mean, ultimately, in those circumstances, it is upon the tribunal, I think, to review the submissions and to make a decision in the circumstances, and try again to apply the ground rules. If the ground rules haven't been complied with, I would be pretty strict. If I feel a party has held back on their case, I'd be pretty strict.
You'd be pretty strict as well in that circumstance, Emma, or are you more understanding?
No, I had an interesting example that you might be curious to hear about, because I think it happens a lot, especially as younger arbitrators. Your first 10 cases usually don't involve very experienced counsel on both sides, which makes them harder. But recently I had a case where it's an ICC case, the first 5 months, the respondent does not show up. And I write incredibly persuasive emails trying to get them to show up, they don't. I of course also make it clear that if they don't, there will be procedural consequences. I will continue, I will decide the case on the basis of the documents before me, and I will make an award, which will be binding on them. On the day when I announced I would close the proceedings, the respondent shows up. And now this is a change of position, right? They decided not to participate, and now they're saying, oh no, we would like to participate. And what they're asking me to do is to give them a chance to file a field statement of defense. And they're being kind of reasonable about it. They're saying, give us 2 weeks. We have everything ready, just 2 weeks, we'll file it, and we'll be happy with that. So I had a procedural call with both parties. A respondent was represented by a non-lawyer, so not really represented, but there is someone there and speaks for the respondent. Claimant was strongly against that. The level of due process vocabulary I got on that call, no, how could I even contemplate this horrible thing? But how I decide, and I think it's probably the way to think about it at least, is prejudice balance. Like, what does the claimant really lose if the case lasts a month longer, compared to what do they lose if it doesn't? And then they get a due process set aside challenge at the enforcement stage. And I thought the claimant was actually pretty short-sighted to be so crazy power of due process against this proposal. So what did I decide? I decided based on what I think both parties' interest is, which is in a resolution of their dispute, an award that is stronger. So I said, okay, fine, you file your statement of defense. I made it very clear that since this is the only thing you request, this is the only thing you're getting. They did that, and I think it was the right decision. But I'd be curious to hear during Q&A if someone else thinks differently.
Thank you, Emma. One issue on which I think one often sees that arbitrators, the tribunals have some fairly strong opinions of their own or preferences of their own is when it comes to both fact witnesses, but also expert witness testimony, how that's conducted. For example, the degree of cross-examination that's appropriate, or whether there should be witness conferencing, hot tubbing. You see the tribunals don't have, they have clear preferences. To what extent is it appropriate for arbitrators to sort of make those preferences clear? And that's another area where there's a sort of bit of a power dynamic between counsel, the parties, and the tribunal. Olena, do you have any thoughts on that particular subject?
So it's an interesting question. So again, if you have a particular presiding arbitrator with a particular style of conducting the proceeding, including in this evidentiary issues, you could expect to have similar pattern in all the proceedings where this arbitrator presides the tribunal. And this might be like parties' expectations, and that is okay. But if parties strongly wish some other way of conducting evidentiary hearing, that might be a dialogue. Again, if the parties agree between themselves and could explain this to the tribunal, to somehow compel the tribunal to accept that, because as Emma already touched this upon, the tribunal does not always accept the parties' agreement. It might sometimes decide otherwise. So there would be a way to agree between themselves and then to have a proceeding which is more convenient for the parties. But what is also important that if tribunal needs or prefers a certain type of evidentiary proceedings in order to, better understand the evidence on record, better understand the what is scope of disagreement between the experts, etc. So the tribunal might feel that this would give an answer to certain questions. And as tribunal is responsible for drafting the award and making the decision, this might be important because ultimately the entire exercise is for them to understand and to decide. And that is why they have their own way how to, perceive information, and how to perceive contradictory information, how to figure out what is right and what is wrong. So from that perspective, tribunal would definitely have some preferences based on its experience in other cases. And so there is no single answer what to do. This all depends. And as a tribunal, so sitting as arbitrator, I would, of course, take into account the parties' position and some important factors, but I would also take into account the issues staying before the tribunal. Because sometimes the expert evidence could be so contradictory, so it's like black and white and nothing overlapping at all. And that might be difficult exercise. Thank you.
So maybe just following on from that and sort of going back to the proactiveness of the tribunal versus passivity question that we touched on earlier, both when it comes to these sorts of procedural issues such as witness conferencing, but also perhaps as another example, if the parties' experts are in some sense two ships passing in the night, the parties seem quite happy with that, or at least don't realize the problem, but the tribunal recognizes that it's not getting the information it needs to make the decision on the proper basis. To what extent should the tribunal really be proactive and intervene?
It's a question to me?
Sorry,
No, it's to me.
It's
to me.
Oh, okay, sorry.
I was writing it down. So my take on these issues in general is that it I do think this is to a large extent party driven. And I'm happy to, as arbitrator, for it to be party driven. I think where, as a tribunal member, you have to speak up is the word that I would use in some way, is when you feel that what is being done isn't conducive to you being able to render a decision where you think there's a possibility of that being in jeopardy. I personally am starting to think more and more that something like what is called a Kaplan process in the middle of an arbitration is very helpful. I think at a minimum, a tribunal check-in after the first round of submissions is very helpful. Right now, I'm chairing a case where we're in the middle of document production, and to decide the document requests, I've had to read both submissions, and some issues have come up, and I intend to convene a call with my other tribunal members to discuss findings, because I do believe we want to talk about some things and maybe take some steps. I think what's often a problem is that the tribunal doesn't read things until the hearing is there. And so I think we should be very much more focused on how do we move away from that. And I think the Kaplan hearing or a check-in in the middle that's recorded in procedural order number 1 in some way is very helpful and not done enough, and should be done more, because it's always the same situation. You get to the hearing, everybody's reading, the tribunal members are realizing, oh, there are ships passing in the night, and then it's too late very often to do something about it. I remember one specific case where we had asked for witness conferencing, for instance, because we felt it would be helpful to have an exchange of the experts. The other side opposed it. The tribunal said no. We arrive at the hearing, and at the end of the first day, the chairman of the tribunal says the tribunal has now discussed this, and we would actually like witness conferencing. And at that point in time, it's really too late. You are putting a huge burden on the parties and counsel. This gets very disorganized. When do you do this? We were then asked to stay a day late. It just, that's not appropriate. That's something you have to think about in advance. And so I do think that many arbitrators fall into that trap. And frankly, I fall into it myself sometimes as well. So I do think it should be party driven to the extent that the tribunal, but up to the extent that the tribunal feels that what the parties are doing is not conducive to them being able to render a fully informed decision. But that should happen earlier on than it happens. And the ships passing in the night, I think, is a perfect example. Expert reports should really be reviewed after the first round, so that if something is really a ship fully passing in the night, which sometimes really does happen, one expert has a completely different valuation method than the other. How do you even begin to, I mean, then it becomes you adopt this one or the other one, but that's not right or correct, I think. So those issues, I think, should be spotted and should be brought up for discussion, again, without, I think, imposing anything, but bringing it up for discussion so that it can be discussed and hopefully an approach can be found.
I'm intrigued by the subject of the Kaplan hearing that Ank mentioned. Emma, what do you see as the purpose of that kind of opportunity to preliminarily address issues in the case? And what do you think the outer limits are? Can it even be a tentative decision in effect of the tribunal that's made at that point? Or is it really just sort of ventilating the issues, or how far can you go with that?
Thank you. Here, I totally agree with you. So on this one, you will not be surprised. But I said at the beginning that I try very hard not to surprise the parties with my decision. And I was just thinking while you were speaking, I think actually in every case that I've handled as arbitrator, I did either do tribunal questions between the 2 rounds of written submissions or a midstream hearing. Now, which one depended on how the parties felt about it. Some parties do not actually want to spend additional money on a full, what they think of as hearing, which means weeks of preparation. But they're more willing to receive tribunal's questions before the second round and then take them into account when drafting the submissions. They would anyway draft. So that's actually a different cost consequence. And therefore it was more successful as a proposal to the parties. How I justified it was simple. It was I wanted to make sure they had a chance to brief me on issues that I think might be relevant for my decision. How do you make sure that you're not prejudging anything? Well, in your own mind, you need to be clear that this is far from brief. That's why you're asking for more briefing on it. And second, you write the questions in a very neutral way. And this is the lawyering moment where they need to be written with a lot of if any, right? Or similar clauses, but they need to be written in a very neutral way. You don't want to be challengeable on that basis either. I don't really think there is a danger of prejudging the merits. I do think there is a danger of not raising something important and then getting to the award drafting stage without all facts, but with a sense of embarrassment if you now go back and ask parties to clarify, which then tempts you not to ask at all. And that's horrible. So I think you should ask them timely before the two submissions rounds.
Olena, maybe just to ask the question as well, just broaden it slightly. What have you seen as effective ways to sort of make sure, either from the tribunal or from the counsel's side, that issues that are at danger of being overlooked aren't overlooked? Do you have any sort of thoughts on that?
I have seen different ways how to do that. And if this is not done on the, like in the middle or on early stage of the case, indeed, what is necessary is sometimes to list, even to make a list of questions to the parties, even after the hearing. This sometimes happens. And in order to avoid some surprise decisions, and when you already on the drafting stage understand that you don't have certain information from the parties or some answers to particular issues raised by one party and not answered by the other party, or you see some legal issue which has never been raised by the parties, but you see this is like a very important issue. So then you have option to come back to the parties with some questions. This should not necessarily be a hearing or case management conference. It could be a list of carefully drafted questions. Why carefully drafted? Just to avoid any risk of challenges, etc. And usually this is addressed to both parties. And I have seen this as a counsel, and I have seen this also as arbitrator. Also, certain arbitrators prefer not to use this, not to come back to the parties. Again, in some institution during scrutiny, this solution could be prompted by the institution if the institution see some risks during the scrutiny process, that some issues were somehow overlooked, or that the arbitral tribunal raised some absolutely novel issues not pleaded by the parties, and this is something to be discussed by the parties. So this is not a tragedy, so it's better to do this before the final award is rendered than to avoid any setting aside proceeding because certain issues either has not been properly treated, or the tribunal just rendered a surprise award going far beyond what the parties have pleaded.
Yes, sure.
Just, Olena, thank you. Something that you said really inspired my further thinking on this. You're right that there are some legal issues that you might see that the counsel has not seen. And that's a horrible situation to be in. It has definitely happened to me. I read the briefs and I think if you only pleaded it this way, you would have had a chance of succeeding. And that's the double heading moral problem almost. Because I had to stop myself from that thinking like, nope, I'm not thinking like that. This is what this party is saying. They're not thinking about the next clause, which could have been the winning one. They're talking about these ones. And so I think there is a real moment when you need to stop and remind yourself you're an arbitrator. You cannot plead, even in your head, the case for that party. What they pleaded is what they're saying, and you decide on that basis. Now, obviously, they haven't pleaded a key jurisdictional issue, may need to raise it to hear briefings about it, But even then, you hear what you've been briefed on, and that's how you decide. You don't have a decision, and then you elicit responses, right?
I could add
Sorry.
here. Oh, sorry. Yeah.
Sorry.
There is an interesting related question of Uranovit Kuria, Uranovit Arbitry. Yes. So whether the arbitral tribunal is entitled to like should know the law, like irrespective of the parties' pleadings. And I would say that according to my understanding, in the majority of jurisdictions, this is not expectation. So this is expectation from the court, but not from the tribunal. But there are some jurisdictions like Switzerland where this is like a normal. There was an interesting discussion in the working group elaborating Prague rules, whether we have somehow include or how we should treat this issue. And you could see that there is a separate article dealing with that, but that article still, so taken into account the response collected from the majority of civil jurisdictions. So still the expectation is that this should be something pleaded by the party, so the tribunal could go a bit further. For instance, if the issue was raised by the tribunal, for instance, relied on a source saying the same thing, but like or just a bit developing the argument raised by the parties, this is okay. But to raise an absolutely new argument not pleaded by the parties, this is not okay in the majority of jurisdictions.
Thank you, Olena. I think we're going to use the rest. We're mindful of the time. I would like to use the rest of the time that we have for questions from the audience, of which we already have one or two now. Please.
At the risk of talking too much, I have a hypothetical to pose.
Could you speak up a little bit more? Just
I
because
have
of
a hypothetical to pose, which puts what you're talking about in a more stark contrast. Assume that the parties have briefed an area of the law and they have missed a critical case that you know. The critical case that you know will decide the case for one of the other parties. And if you take the view that it's purely the party's process, and you don't care if you get the law wrong, then you just take what they've cited you. They didn't find this case. But if you want to get the law right, then you say, well, have you thought of this case? You know, I think I would like some briefing on this. What do? I think that puts in stark contrast the concept of the party's process versus some judicial aspect to what an arbitrator does.
I agree. I think those are the borderline situations that I was talking about very much at the beginning. I find those very difficult questions. In your hypothetical, I would raise the case. I think it's a travesty if you don't raise the case, personally. So I would raise it, but I do. It's a very difficult decision in every single time something comes up. I think it's a matter of degree. I do think you have to be careful not to plead someone's case, but I also do. I do have a internal conviction that yes, we must in the end reach the right result. And certainly when it comes to the law, as you said, a point of law, to me, it must be raised. I can't see how you can't raise it, but it must be discussed. It must be put to the parties. They must both have an opportunity to comment on it. But I could personally not render an award where the critical case in the area of the law has been overlooked. I couldn't do it.
I had that situation. It was the case under English law. A key issue was interpretation of unfair terms. And I knew that there was a case issued like 7 or 8 months after the last case the claimant and respondent discussed. And what I did was very sneaky. In my tribunal questions, I wrote back saying, the tribunal will be grateful to hear if any further cases or later decide that could inform the tribunal's decision. So I really push them to do more legal research, people. I just go back to practical law and tell me the answer. And that motivated a claimant to find that case. They still didn't get it fully correctly, but at least they gave me an exhibit number to quote. So, but I'm with Ank. I would find it extremely difficult to issue an award that I know is legally incorrect. And then we'll go to the court for potentially for a challenge and my name is on it and I'm embarrassed. Like, no, I would find it very difficult. But there are ways to, I think, elicit responses.
We have another question here.
Yes, the Prague rules have been mentioned several times by Olena. The question I have is, since it does deal with many of the issues that we have talked about today and does provide a great deal of authority to the tribunal to handle these things, for example, bringing all issues up front, deals with discovery, expert witnesses and the like, but it's not a popular rule. So my question to the panel is, do you see more of the issues that are handled in the Prague rules being incorporated, whether in rules in the West or just by practice?
Olena is our expert on the Prague rules. I'll give that one to you to answer first.
Thank you. So actually, I have seen many of the tools described in Prague rules used in practice, not necessarily in arbitration rules of regional local institution, but in practice. So that is why this is not something new. This is rather a collection, of some practice, average practice in civil law jurisdiction. So, and I see, I have used these rules in my proceedings, and I know arbitrators who did the same. So there is definitely a market and users for this type of rules and for this type of more proactive arbitral tribunals. Thank you.
Just out of curiosity, have either of you seen the Prague rules come across your desk in arbitrations that you've been involved in?
I have not.
Seen them in a clause, haven't seen them in a case. So.
TBD.
Yeah,
if
exactly.
that ever generates.
Exactly.
Any other questions from the audience at this point? Oh,
Well,
sorry.
It's not a question, it's just to, coming back to the hypothetical, I fully agree with Hank, but I would really very much insist on the fact, as you already said, that you have to raise the issue and bring it to the attention of the parties and speak their opinions.
Mm-hmm.
Otherwise, you might risk a breach of due process. That's another category of difficulty for the arbitrator, but I fully agree. Again, we are there to settle the dispute at law. In particular, if the governing law has already been chosen by the parties, so it's crystal clear which law is governing. We have to do exactly within that. Also, I might add that your hypothetical is probably because you rely so much on one case that you are assuming a common law jurisdiction, the law of a common law jurisdiction applies. If it was a civil law jurisdiction, generally most of the law is codified, so the outcome does not really depend on one judgment, generally, although there are exceptions. But again, I fully agree with you.
Yeah, I mean, I can't emphasize this enough. There should be no surprises in
No,
the award. And I
absolutely.
want to
Definitely.
emphasize it because even though everybody agrees, it happens so
Sure.
often.
It does.
The cases are big, they are complex, and almost every award that I get has some aspect in it that was not discussed, was not brought up, and I'm just surprised time and again that even though we all agree, we all know it, it happens. The cases are very, very complex and big, and there's many issues that arise. And I do think there is some sense of embarrassment, or there's already been a lot of delay. The tribunal really wants to get the award out, but if something comes up that wasn't discussed and it's going to be a basis for your decision, it cannot be a surprise.
So let's assume the hearing has been closed. The tribunal is now conversing, and all of a sudden it comes up. What do you do?
You have to go back to the parties. You have to try to avoid it. Again, by at a minimum, I would say before the hearing, the tribunal has to come together and have a discussion and see whether there are questions. And then you have to do that again during the hearing and toward the end of the hearing. My preference is to get questions out at the latest, a couple of days after the hearing, so that the parties can take it into account in their post-hearing briefs.
Post-hearing,
That's
yes,
the,
the
that's the,
post-hearing
that's the
briefs.
last moment.
So,
We have a question in the back row I'd like to get to. Sorry. Yeah.
Well, it's similar, following up, but if
Sorry,
you,
with Zoom on.
if, let's say you don't know that there's an outstanding case because you don't know everything, and then how does that play into it? Because you're not gonna go do your own research and say, are these lawyers competent enough? And then, so you could still come away with the wrong award because they didn't bring it up to you and you didn't know about it.
You could, I agree. I don't do my own legal research.
Yeah, so then, playing in on that, like how much responsibility do you have to keep yourself aware of the law in the area that you're practicing? Or is it just a matter of coincidence that you know that this was the case that they should have brought up to you? It seems like a lot of tension, internal tension on staying competent as an arbitrator, but really not doing their job for it.
I mean, I think the answer is yes, it would be coincidence, to be honest, because I don't proclaim to know on any, like if I do commercial case and it's under New York law, I don't proclaim to know every single case of New York law on a certain issue. And so, yes, it may be coincidence. I don't do the research myself. I don't think that's within my duties to do. So yes, to a certain extent, it is coincidence. I would say that in most cases that I sit in, the key cases will probably, I will probably know the key cases and the key trends, but yes, it may very well be coincidence. It doesn't sound very satisfying, but that's the truthful answer from me.
One more question.
Just very briefly, just to follow up. I mean, I'm less certain about that. I mean, I'm not doing a research. I mean, probably it's fair to say that most arbitrators don't do research beyond what the parties
Right.
bring to the tribunal. Probably that's the case, at least most frequently. I mean, I would hesitate. I would not say necessarily that the arbitrator is not to do research on his own.
I
would
didn't
not
say
go-
there's a prohibition, right? I just
No,
say
no,
as a practical matter, I do not go and research the issues myself.
Okay, it's a practical matter, but again, if we are there to settle the dispute at law, we should be at least very, very familiar with the governing law. So we should be aware of law beyond what the parties say. It's always the Jura Novit Curia problem. No problem. I'm not saying anything new. But again, I mean, we should not be in the position where the parties, their counsels are weak on the knowledge of the law and the tribunal is also weak. We should never be in that position, although it might happen.
As is clear, we could go on for quite some time on
Sure.
these issues, and they're really very practical. But I think we've now reached almost the end of the panel. I do want to give all three of our panelists the opportunity for a very brief, a very brief final few words. Any thoughts you want to contribute briefly that you haven't already said?
I would just encourage everybody to demand quality. I think we end up with a better system if people are transparent about their expectations. And if they ask of their appointed arbitrators to only take a case if they're available and have desire to bring real attention and effort to it. So yes, read the submissions as they come in, please do, so you can put forward informed questions. If you don't have time the next 4 years to write an award, don't take the case. I mean, the pool is wider than ever. There are enough people who are ambitious and committed to our profession who can take the cases on. So I think that's the key word, but really the demand needs to be on the users. They need to be clear about what they want and act accordingly.
Olena, any final thoughts from your side?
Yeah, two questions. Indeed, I agree that if parties want to be more satisfied with the end result, they need to have really available and dedicated arbitrators first, and there are some tools like probably expanding the pool of potential candidates. And second, in order to be satisfied with the end result for all the participants of the arbitration, is actually to manage expectation. And in order to manage expectation, because all the frustration we could have when our expectations like are not met, either from the tribunal side or from the party side. And in order to solve this issue, solve the dialogue between the parties as the tribunal is very important. And I think many questions should be asked either by parties or by the tribunal in order to avoid any complication or some unexpected negative result for any of the participants. Thank you.
Final thoughts?
I agree with that. The key point is Emma's point. Related to it, I guess I would say as counsel, to have confidence that the arbitrator, most arbitrators want to do well, want to get it right. In our discussions prior to the panel, there was sometimes a comment of parties are very afraid, they don't want to offend the arbitrators. In my experience sitting on tribunals, arbitrators are well-meaning people, they want to do well, and if you point something out reasonably and respectfully, and you make them realize that they may have been on a little bit of a wrong course, many arbitrators will appreciate that and not retaliate, not be vindictive or anything of the kind. So that's something that has come a little bit for me with experience. The realization that if I really have a good point to make, I should feel free to make it, be allowed to make it, and hopefully have appointed arbitrators who are conscientious human beings who are willing to see that we're not perfect, and if we are if we realize we were on a bit of a wrong course, to have the humility to be willing to change the course, and I think most arbitrators do.
Thank you very much. Thank you to my panelists. Thank you to the audience. Now is a good time to applause.